Hi, my name is Joseph McDaniel and I'm a bankruptcy attorney, and since 2005 I get to tell you that I'm a debt relief agency and that I help people and businesses file for bankruptcy under the bankruptcy code. Today's bankruptcy statement is, if a bankruptcy expert tells you not to list an asset, they aren't a bankruptcy expert. I recently heard back from some clients of mine who were off doing some bankruptcy homework in preparation for filing their Chapter 7. We'd found a way that they could file, so they were pretty happy. I suggested that they talk to some folks to see what it would cost, that is, get a written estimate, to bring one of their cars up to excellent condition, per Kelley Blue Book, and what their house was worth, and what their wedding ring was worth, and I gave them a few other projects just to get them tidied up and ready to go. When they came back to see me, they'd gotten some bankruptcy advice from a bankruptcy expert who wasn't an attorney. He was a mechanic, or maybe a real estate appraiser, or something. And the advice he gave them was simple. He told them, don't list your valuable thingamajig because the trustee will take it away from you in your Chapter 7 bankruptcy. Now, I've talked about pre-bankruptcy planning in several places on the internet, and I've lectured about it for several bar associations. There's always some risk associated with it because pigs get fat and hogs get slaughtered. But both Judge Haynes and Judge Curley have written instructive opinions on that topic. But this is one piece of free advice that may be more valuable to you than any other. If a buddy who filed a bankruptcy back in 1950 tells you that you shouldn't list an asset, or that you should sell your asset and stick the proceeds in a box under your bed, he's not really your buddy. Or at least he's not a very smart buddy. Now, I enjoy hearing questions, and many questions revolve around what you get to keep in a bankruptcy because of the Arizona bankruptcy exemptions and certain federal exemptions, and the fact that some assets are over-encumbered, and the fact that some assets are simply worthless, along with your heavily used antimacassar collection. But one question I never spend too much time on is this one. Is it a good idea to hide my assets, or sell them to my sister for $1, or give them to my parents just prior to filing my bankruptcy? The answer is always simple and short, unless I'm being a smart aleck that day. No. Legitimate pre-bankruptcy planning, in which non-exempt assets are converted to exempt assets prior to filing, always has some risks, and you need to do it correctly, including selling for fair market value and listing the transfer on your bankruptcy schedules. Thank you very much.